Hello, everyone. So this week we are going to be talking about really the bulk of what psychologists who work in the law do, which is assessment. And so we're going to talk about how do you assess someone in a criminal setting, and then the other chapter associated with this unit, we're going to talk about how you assess someone in a civil setting, because we can be relevant there as well. Oh, and you guys got a little view of Finley passing us by there. That'll happen occasionally. So first we're going to talk about competence to stand trial. And because the lecture is longer for these couple chapters, I'm going to break it into a couple of videos. So we're going to talk just about competence in this particular video. And then we will talk about not guilty by reason of insanity and some other issues and some other related videos. So a little bit of history here. The idea of competence to stand trial originally came from English common law. And this was in the 17th century. In English courts, there were defendants who stood mute. And they said they could be mute by malice or mute by visitation of God, essentially mental illness. So if they were mute by visitation of God, then they didn't have to enter a plea. Essentially, they were saying, well, there's a reason this is happening. In 1790, there was Frith's case, where the court delayed trial until such time as the defendant, and this is a quote, by collecting together his intellects and having them entire, he shall be able to model his defense and to ward off punishment of the law. So delay until his mental facilities could be intact. The 6th Amendment of the U.S. Constitution includes the right to assistance of counsel, and that becomes relevant here. In 1899, Utsi v. U.S. Was a case where the main person, Utsi, had epilepsy, and so he was unable to go on trial for embezzlement. Here's another quote, doubtful whether the accused was capable of appreciating his situation and of intelligently advising his counsel as to his defense if he had any. So what's the legal basis for this idea of whether or not you're competent to stand trial? Well, accuracy. Accuracy depends on the assistance of the defendant in the trial. The defendant has to be able to work with their legal team. Due process depends on the ability to exercise your rights. Integrity and dignity of the process are undermined by the trial of incompetent individuals. And the objective of the courts is not served when the defendant doesn't understand the punishment. I mean, this is a correctional system. We can't correct things if they don't understand what they did wrong. So when is this issue raised? When there is a quote-unquote bona fide doubt. This comes from the case Pate v. Robinson in 1966. Any person can raise the issue of competency. It can be the lawyer on either side. It can be the individual themselves. And then the judge will decide if there is this quote-unquote bona fide doubt or bona fide possibility of incompetence. The judge then has to order a competency evaluation by a psychologist or a psychiatrist. The court pays for the competency evaluation, and either side can decide, in addition to what the court's doing, I want an independent evaluation. Usually this will be the defense, and they'll ask to see the results of the court-ordered one first, and they'll question the conclusions. At that point, when you ask for an independent, the defendant pays if they have the resources. If not, the court will also pay for this one. During this time, all the other proceedings have to be put on hold because the idea is we can't go forward until we know whether or not this person is competent. There's a separate trial to determine competency. And percentage often surprises people. So the issue is raised in only 2 to 8% of felony cases and 5% of criminal cases. A lot of people think this is raised much more often, partially because of movies, TV, sort of glorifying, glamorizing this. So of that 2 to 8%, 2/3, the judge says, yes, we will see if this person's actually incompetent. So 2/3 of 2 to 8%. And of those 2/3 of 2 to 8%, only 1/4 are found incompetent. So this ends up being less than 1% of all criminal cases are actually found incompetent to stand trial. This is something that I think is really important, another sort of myth-busting moment. This doesn't happen that often. People are not just getting away with things because they're claiming to be incompetent. And part of that is due to an important note here, which is that the defendant is assumed to be competent unless proven incompetent. So the burden of proof here is on the defendant. Okay, so that makes this quite difficult, actually. And there's some YouTube videos associated with this unit where folks sort of talk about that. So what are the criteria for incompetence? A couple different ones are used. So Dusky v. US in 1960, you have to be able to consult with a lawyer. So you have to be able to consult with a reasonable degree of rational understanding. And reasonable is what the average person involved in a court proceeding would understand. So it's not understanding everything. It's not understanding all the legalese. You have to understand what the average person would. You have to understand the charges against you. So you have to have a rational and factual understanding of the procedures against you. Wider v. Settle was a follow-up to the Dusky case and articulated the components of competence. So first is, are they oriented to time, place, and things in relation to that person? Do they know who they are, where they are? The second is that the person recognizes they are in a court of justice and actually charged with a criminal criminal offense. The third is that they understand there's a judge on the bench. The fourth is that they understand there's a prosecutor who will try to convict them. The fifth is that they understand they have a lawyer who will try to defend them. And then the sixth is that they will be able to be expected to tell their lawyer the circumstances of the crime to the best of their mental ability. Seventh is that there will be a jury present and understanding what the jury actually does. And then eighth is that, I'll sort of read a quote here, they have the ability of memory enough to be able to relate these things. So they don't have some sort of traumatic brain injury that's impaired their memory. Cooper v. Oklahoma in 1996 established the competency standard. So it's the preponderance of evidence, which is that 51%, or some people will say 50% plus a feather. And again, this is a fairly low standard. It's not the beyond the reasonable doubt. Now, what do competency evaluations entail? Again, this is where the psychologist will be involved. So foundational competence is, does the defendant understand proceedings and possible outcomes? And again, this is that reasonable understanding. They understand they could go to jail, not that they understand the minutia of case law. Then there's decisional competence, which is competency to make decisions at the trial. Can they actually cooperate with their attorney in preparing their own defense? In most jurisdictions, psychologists also need to assess whether the individual can be restored to competence in, quote unquote, a reasonable amount of time. So the idea is, can we get this person to the point where they will understand and be competent? Or is it a lost cause? So in terms of the actual evaluation, the first thing that happens as a psychologist is you get information from the court order or referral. Okay, this is why this person's being referred. You're going to talk to the person's attorney and say, can this client cooperate? See why and how they're considered incompetent. And you're not necessarily going to accept this at fact. Remember, this is coming from the attorney who has to defend this person. But it's a useful piece of information, useful sort of jumping off point. Then you're going to do an interview. General clinical topics, very similar to the interviews we've talked about previously for other assessments. You're going to ask that person open-ended questions, see how much that individual can give you without prompting. For example, do they know what's going to happen? Judge, jury, attorneys, witnesses, those types of things, the process. So an example question might be, what would you do if someone says something about you that's not true during the court case? And they should say, be upset, maybe talk to my attorney about it. They shouldn't say, I'm going to run up and punch them in the face. Right? That's just not going to be acceptable. Another good question, do you understand why you're here today? If they don't understand it, you have an obligation ethically to explain to them the purpose of the evaluation. So that's something really important to know. You're also ethically obligated to let them know what will happen with this information. So it will go to the court, and the court will distribute it to the attorneys. The court is your client here. It's not the person who's in the room with you. So there's not that client psychologist privilege or confidentiality like there is in a clinical setting. Then you're going to administer some sort of standard competency instrument. This will allow you to gather information to help you make decision about if the person understands enough. And words we're looking for here, again, are not like perfect, but reasonable or substantial. Then you're going to prepare a written report that goes to the judge. And what goes in that report? Well, a whole bunch of things. You have to put in the reason for the referral. So why was this person referred to you for this particular evaluation? You want to put in your sources of information. Who did you talk to? Just the person, maybe their spouse, their attorney. What sort of test did you do? Then you want to talk about their background. What's this person's age? What's this person's history? Have they been hospitalized or treated before for psychological issues? Did they have a head injury? What's their educational background? Obviously, someone with a PhD or a JD, right? is going to have a different type of knowledge than someone who wasn't able to finish high school. And what's their family like? Then you want to address the question of competency. Again, talking to the attorney, talking to their families, the interview you did, the test specific to competency, which we're going to talk about on the next slide. You want to talk about how much they understand. You can say things here, and it's really important to say things here that, like, this person does not trust their lawyer. Describe things like delusions or hallucinations. Say what you've concluded about the individual in relation to aspects of competency. So in some states, you can't address what's called the ultimate issue. So the ultimate issue is deciding whether that person's competent or not. And in some states, they say this is the ultimate issue for the judge to decide on. So you as a psychologist are not allowed to actually give your opinion directly on that. But what you can do instead is address all elements. So you can say, they understand what a lawyer is. They trust their lawyer. They understand the jury. They understand the process. But then you just have to leave off the sentence that says, therefore, I believe Mr. X is competent or Mrs. X is incompetent, right? Most states, however, do permit and require, in fact, psychologists to address the issue of competence or the ultimate issue. They must address, in addition, what's called restorability. So the amount of time it will take to get that person up to being competent and understanding. And you can't address that unless you've said this person isn't competent, right? It's sort of a moot issue to say, yes, we can restore this person to competence if you can't say that they are competent. You don't address like a treatment plan or what does need to be done. You just say whether or not you think that person can be restored. And if they are found competent to stand trial, that's it. There's no recommendation to have them restored because they're already there. And you either imply that or say that, depending on your municipality. So what tests are used? There's a whole bunch of different things that can be used here. And usually competency exams are where standardized instruments are really, really helpful. in general because they evaluate your status right now. Other questions we'll talk about later, including not guilty by reason of insanity, the time becomes an issue. But for competence to stand trial, we're talking about the person in the moment right now, and that's what most psychological evaluations and assessments and tests are created to do. How is this person performing or feeling or doing right now? So this actually works for competency. So it's recommended that you do one general instrument and one specific to competency. So an example of an instrument that is general is the Wechsler Adult Intelligence Scale, or the WAIS. And this is a highly standardized assessment of intelligence. It's really considered the gold standard of intelligence assessment in the field. And this gives you their level of general intellectual ability in relation to the norm. And it's important to note, however, that just because you get someone's IQ doesn't mean that they are or are not competent. So for example, you could have someone with an IQ of 120, which is coming close to genius levels. They for sure have the intellectual ability to understand what's going on, but that doesn't mean they understand the specifics, and it doesn't mean they might not have something going on like a psychotic disorder that could interfere with their ability to be competent. Similarly, if you have an IQ of 70, you have limited intellectual ability, but that doesn't necessarily mean that you're incompetent. You could still understand what's going on, and that's all you need to do. Then there is, again, these tests specific to competency. Couple examples here. The MacArthur Competence Assessment Tool, Criminal Adjudication, or the MAC-CAT-CA. This is the most often used instrument in this scenario. There are 22 items and they're scored 0, 1, or 2. And it addresses both knowledge and understanding, so what that person knows, and also reasoning, or their capacity to understand new information. And these are separate subscales. There are norms that exist for this, although with somewhat limited data. There are not, however, validity indices that let you know whether this person's actually trying adequately or lying. So you have to administer something else in order to get those type of validity things. Then there's the MacArthur Structured Assessment of the Competence of Criminal Defendants. So this is the MAC-SAC-CD. And this consists of a vignette about which the defendant is asked 82 questions that tap both the foundational competence and decisional competence abilities. Defendants are asked open-ended questions first, and then if there's a wrong answer, correct information is provided to the defendant, and then they're questioned again. So can they retain this new stuff? And just a side note that the MAC-CAT-CA is more of a clinical version of the MAC-SAC-CD. So here you again might have a hypothetical vignette about a crime during which the first 16 items are based, and these items assess the defendant's general understanding of the legal system and adjudicative process, and his or her reasoning abilities in legal situations. The remaining 6 out of 22 items on the MAC-CAT-CA are specific to the defendant's own legal situation. There are other instruments that are acceptable to use and often used quite well. One is the MMPI that we talked about before, not just the MMP. I apologize for the typo on the slide here. And this measures your general level of adjustment, the presence or absence of severe or psychopathology. So do they or do they not seem to be severely psychologically distressed? But it doesn't address the specific issues. The one good thing the MMPI is good for as well is it does have those validity indexes built in. So you can see if the person is trying, if they are lying to you, trying to fake good, fake bad. The PAI is a similar test, also going to give you some of the same information to the MMPI, and also has those validity indices. One side note before I get into the more specific ones is that projective instruments, things like the Rorschach inkblot test that you often see in movies and TV shows, these are not recommended because there's a lot of criticism about them. There's not a lot of research, and in fact, modern research has really just sort of poked holes in them. And again, anything you say in your report is going to be criticized and scrutinized. So you want to only use things that don't have that kind of critical, not great background, right? You want to use very solid tests with a lot of research behind them. So a couple other things that are specific here. Competence Screening Test, or the CST, is a 22-item sentence completion task designed as an initial screening for incompetence. The Competency Assessment Instrument, or CAI, is a more in-depth instrument. It's a structured 1-hour interview that covers 13 functions relevant to competent functioning at a trial. The Interdisciplinary Fitness Interview, or the IFI, is a semi-structured interview that evaluates a defendant's abilities in 5 specific legal areas and assesses 11 categories of psychopathological symptoms. The Georgia Court Competency Test, or GCCT, consists of 21 questions that tap 3 dimensions: general legal knowledge, courtroom layout, and specific legal knowledge. Evaluation of Competence to Stand Trial Revised, or ECSTR, is a semi-structured interview that was developed using the Dusky criteria in particular, and it assesses factual understanding of proceedings, rational understanding of proceedings, and consultation with counsel. Unlike others, this test uses information specific to the case of the individual being evaluated for competence, and has a measure to assess possible exaggeration. So it has a validity measure built in. Estimates of malingering, faking or grossly exaggerating mental illness incompetence evals are close to 18%. So not everybody, but certainly enough that we want to be careful. Then there's the Miller Forensic Assessment of Symptoms Test, or the MFAST. And this is a 25-item semi-structured interview that can identify individuals who are attempting to feign mental disorders. So it can kind of get us to that 18%. You want to adopt a comprehensive approach here. You do not want to just rely on one data source, and you want to integrate this information. That's really, really important. So in terms of how the decision is actually made about competence, it's made by a judge at a separate hearing from the actual trial itself on whether this person's guilty or not guilty. And it's based on evidence from that competency evaluation completed by the psychologist. And the defendant is present, and they're represented by counsel. The trial includes any evidence about competency from the defendant, the attorney, the psychologist. And here it's really important to note that your report is almost always accepted into evidence without testimony. I think I mentioned before, I shadowed a forensic psychologist once, and she said she had to testify maybe once every 6 months. Now, if you're in more contentious cases, that might happen more often, but this is, again, why this report you write is so important, because if you write it well, you don't have to go testify. If the person's found competent, the trial proceeds as if this issue had never been brought up from the place where that issue was raised. So you just kind of reset. If they're found incompetent, it really depends on that prediction of restorability to competence. If they cannot be restored within a reasonable period of time, then they are committed. And being committed is in and of itself yet another separate proceeding. It's a civil proceeding. They have to meet criteria for involuntary civil commitment, which is usually that they are dangerous to themselves or someone else. That person will regularly be reevaluated to determine if they continue to be a clear and present danger to themselves or others. And it used to be people would just stay for the rest of their lives. Now they're typically released, and then they often end up hospitalized or in jail later. Or they can be released and the charges dropped. If there's just no way this person can be restored, and being committed would actually not be helpful and may be harmful. If they are considered restorable, then they are treated and they're sent to a criminal psychiatric facility. I think this is really important for people to note. So they are going specifically to a facility for this. So they have to be able to be restored within a quote-unquote reasonable amount of time, reasonable period of time. So this comes from Jackson v. Indiana in 1972. And so for serious crimes like rape or murder, this has been said at 1 year. For less serious crimes, this has been set at 6 months. And that might not sound like a long amount of time, but we have treatments that can work in 20 weeks for things like depression. So certainly we should be able to restore someone to competence within that given period of time. This is not, however, going to be general mental health treatment. The focus is just teaching that person to be competent, teaching them about the legal system. And then they will be periodically evaluated by the court to determine if they have been restored to competency. It can be done at the recommendation of the treatment facility if they say, yep, this person seems to be restored, or it can be mandated at regularly scheduled times. So for example, every 6 months. And then at that point, another competency evaluation would be performed. If they're found restored to competency, then they would go and stand trial. If not, if they're at the end of this quote unquote reasonable period, the person is sent back to, if they're not done with the reasonable period, then the person's sent back to treatment. But if it is at the end of this reasonable time period, then they are considered to be quote unquote never restorable, and the charges will be dropped, and then they'll go through that civil commitment process. A large proportion of people found incompetent are eventually restored to competency. So they do get that understanding. So in terms of the results of competency evaluations, about 70% of defendants referred for evaluation are ultimately found competent to stand trial. So what sort of person is most often judged to be incompetent to stand trial? And you'll sometimes see this abbreviated as IST. The typical defendant has a history of psychosis. Psychosis is what we expect in something like schizophrenia. So hearing, seeing, touching, tasting, smelling things that are not there, believing fixed false beliefs that are just not outside the realm of reality. They have symptoms of a serious mental disorder that's current. They are often single, unemployed, and poorly educated. And maybe not surprisingly, they are going to score poorly on competence assessment instruments. So that's sort of cyclical, right? Now, there are some special considerations that we need to think about here. So one is developmental delay or disability, what's been called in the past mental retardation. One important thing, as we mentioned before, is this doesn't necessarily equate with incompetence. You shouldn't assume it either way. You shouldn't assume they are competent. You shouldn't assume they are incompetent. You should evaluate them with the same criteria as usual. Another challenge is communication deficits. What if that person is deaf or mute, or they do not speak English, right? The court must then provide assistance. They have to have an interpreter for American Sign Language or for whatever language that person speaks, or descriptions and feeling rather than sight for blind individuals, okay? Amnesia, again, does not also automatically make you incompetent to stand trial. Just like with mental retardation, you shouldn't assume one way or the other. So Wilson v. U.S. in 1968 addressed factors to consider in deciding whether fairness and accuracy of a trial will be compromised by amnesia. So the first is the extent to which the amnesia affected their ability to consult with and assist their lawyer. The second is the extent to which the amnesia affected their ability to testify on their own behalf. The third is the extent to which evidence could be extringently reconstructed in view of the amnesia. So are there other people who could tell the same story? Do we have video footage? The fourth is the extent to which the government assisted defendant and counsel in reconstructed. Fifth is the strength of the prosecution's case. If there's any suggestion that the person would be able to establish an alibi or other defense, if not for the amnesia, you have to take that into account. The sixth is facts or circumstances that indicate it's not a fair trial. Another issue is forced medication. In this case, the medication would be ordered by a judge, where there would be just no less intrusive way to do it. No evidence would be detrimental. So, for example, the person has schizophrenia. The judge says they need to be on antipsychotics in order to be competent to stand trial. This is used if it will restore the person to competence and help them stay competent during the trial. So it's for those circumstances only. There are special type of competence we need to think about here. Competence to waive your Miranda rights, right? We talked about these when we talked about some of the other issues. The Miranda rights are rights for guaranteed, and you can waive them. But the waiver requires that defendants, once in police custody, makes a confession after having waived their Fifth Amendment right to avoid self-incrimination in a knowing, intelligent, and voluntary fashion, right? So they have to be competent to do that. This assessment is challenging because typically the waiver and confession have occurred months before you get to a psychologist to evaluate whether they were competent at that time. We'll see very similar issues when we talk about NGRI. The Supreme Court has held that defendants have a constitutional right to waive counsel and represent themselves at trial, providing that this decision is made competently. And this is from Ferretta v. California in 1975. In addition, the presiding judge must be convinced that the waiver of counsel is both voluntary and intelligent. So that can relate here as well. You have to actually be competent to try to plead not guilty by reason of insanity, to use the insanity defense, which is really interesting. Can the defendant refuse to plead insanity? In some ways, the court have suggested that only mentally responsible persons should be punished, thus requiring the imposition of an insanity plea even on people who are like, I don't want to say that I'm insane. And this comes from Whalen v. U.S. in 1965. But in Frendak v. U.S. in 1979, they said that if the defendant understands the alternative pleas and their consequences, they should be permitted to reject the plea. But you have to show that you understand it, that you're competent to reject it. You have to be competent to be sentenced. In general, the standard is that the defendants can understand the punishment and the reasons why it's being imposed and can meaningfully execute their right to address the court at sentencing. You have to be competent to be executed. The U.S. Supreme Court decided in Ford v. Wainwright in 1986 that the Eighth Amendment ban against cruel and unusual punishment prohibits the execution of defendants when they are incompetent. It's cruel and unusual to kill someone who doesn't understand why they're being killed, essentially, for a crime. Atkins v. Virginia in 2002 actually said it's unconstitutional to execute a mentally retarded or developmentally delayed individual. The idea is that someone who has this is unable to understand the nature of what's going on. And again, this is tied to the Eighth Amendment, the cruel and unusual. Psychologists are often called in to address this particular issue. And the issue becomes, what is the cutoff? Is it an IQ of 70? Is it some combination of things? The court didn't define this. So, and then how does this relate to the functioning of the individual? In terms of competence of juveniles, researchers have found that participants who were age 15 and younger were significantly impaired in ways to compromise their ability to function as competent defendants in a criminal or adult proceeding. Now, in terms of what happens if you have someone who is saying, I'm not competent to stand trial and I'm not guilty by reason of insanity, which is what our next little mini lecture will be about. Those are two separate questions that should be done in two separate evaluations. Often, however, referrals for both are made at the same time to the same forensic psychologist. And you can gather both data for both from one contact with that person. But they're separate information and they can't be used in the report for the other issue. Competency should obviously be able to be addressed first. You can't say, yeah, we're going to go through a trial and see if you're not guilty by reason of insanity if you're not even competent to stand that trial. You have to be really careful with insanity because none of the conclusions about competence should include NGRI as a reason, or vice versa. You can't say because they're incompetent, then they're not guilty by reason of insanity. The temporal issues become a real issue here as well. For competency, you're talking about now and in the future. So can they continue to be competent throughout the trial? For NGRI, you're talking about the past mental state of the person at the time the crime was committed. And that could be 90 days ago, that could be a year or several years ago. A key element of your response is that the person's account of their behavior at the time of the event is related to NGRI. And we're going to talk about this again much more in the next mini lecture, but often you admit guilt when you're saying you're not guilty by reason of insanity, because you're saying you committed that crime, but you're not guilty of it because you weren't yourself at that time. And it's only related to competency if you can't give a coherent account of the crime. Okay, so that's where these sort of intersect. All right, I hope that this helped clarify competency, and in the next mini issue, we will talk about not guilty by reason of insanity separately.